Welcome to another episode on the law rapport. Today, I would like to discuss the Actus Reus and the Menswear in criminal law. But before I do so, disclaimer, this is not legal advice, should not be construed as legal advice, and for legal advice, please contact a competent lawyer of your choice. Now, in every criminal offense, there are two terms that are essential. If the prosecutor or the prosecution is to secure a conviction against the person who allegedly commit the offense or offenses charged. The first is called the Actus Reus, commonly referred to as the Guilty Act. Unless the contrary is specified, every criminal offense requires both a criminal act, expressed in Latin as the Actus Reus, and a criminal intention expressed as mens rea. Now, human nature is of such that people think evil every day, but evil intentions, even reprehensible, if not acted on, are of no concern to the law. The law is not obsessed with seeking out people and punishing them for their evil thoughts. The law will not interfere unless there has been some conduct, some physical manifestation of the evil intention. Some crimes only require the slightest manifestation. In cases where persons are charged with the offense of conspiracy, all that is needed is an agreement to commit the crime. No matter how minimal it might be, the agreement is nevertheless a physical manifestation of the evil intention. It is conduct and can form the basis of the Actus Reus. The Actus Reus of every crime is different. Each crime will require different elements to be proven before a person charged with the offense could be convicted. For example, in a case where a person is charged for the offense of theft, the Actus Reus is the appropriation of property belonging to another. In a case of rape, the Actus Reus is penetration of the vagina, the anus, or the mouth of another person without their consent. These are called conduct crimes. However, there are some crimes referred to as result crimes. With result crimes, it is necessary to establish an additional third element, which is the act that caused the prohibited consequence. For example, a result crime is one of causing death by dangerous driving under the road traffic ordinance. Putting these elements together, it is reasonable to define the Actus Reus as 1. An act, 2. Committed in legally relevant circumstances, and 3. For result crimes causing the prohibited result. The issue of causation is thus treated as part of the Actus Reus requirement, and causation deserves an episode by itself. So for the purposes of this presentation, I will not go into causation. The act must be voluntary. There must be an act and there must be voluntary human conduct. However, a crime may be defined in such a way in statute that no conduct is required, but the crime is committed when a certain state of affairs exists or the defendant is in a certain condition or is of a particular status. For example, in the case of Windsor and Chief Constable of Kent, the Times, March 28, 1993, Queen's Bench Divisional Court, the defendant was brought to a hospital on a stretcher. The doctor, having examined him, discovered that he was merely drunk and asked him to leave. He remained in the hospital compound and the police were called and they moved him to the roadway, having formed the opinion that he was drunk. They placed him in their car park nearby. The defendant was subsequently charged with being found drunk in a highway and he was convicted of the offence. He appealed against the conviction. Robert Goff, LJ, had the following to say, and he asks a question: does the fact that the appellant was momentarily in the highway and not there of his own volition prevented his conviction of the offence of being found in a highway? And Lord Goff answered the question in the negative. The point, he said, is simply that the offence is committed if a person is perceived to be drunk in a public place or in the highway. Once that criterion is fulfilled, then the offence is committed. So the court held that it mattered not that the defendant was in the highway because he was placed there by the police officers. What mattered is that he was of a particular state or particular status, and that was that he was intoxicated. And once he was intoxicated in the highway, it brought him within the ambit of the legislation. And so whether or not he was there voluntarily was irrelevant. An omission may fulfill the requirement of the Actus Reus in a particular crime. Although most crimes are committed by positive action, and thus the requirement of an act will usually be met by a positive act. But in certain circumstances, a passive failure to act may be deemed to constitute the requisite act. A failure to act may result in the imposition of criminal liability in two situations. In conduct crimes, the failure to act may itself without more constitute the crime. Thus, this usually occurs in statute where crimes are specifically defined in terms of an omission to act. For example, failing to provide a specimen of breath or blood or urine sample under the road traffic ordinance. In result crimes, the failure to act may contribute towards the harm specified in the offence and in certain circumstances be deemed the requisite act for the purposes of the offence. This will only be so if the person is under a duty to act. For example, a father would be under a duty to rescue his son, a young child, drowning in a shallow pool. The failure of the father to act would constitute the requisite act of the crime of homicide or murder. However, a stranger could watch with impunity without attracting any criminal liability because in English law there is no general duty to act. In the case of Regina and Miller of 1982, the House of Lords case, Lord Diplock stated the following, and I quote, "The conduct of the parabolical priest and the Levite on the road to Jericho may have been indeed deplorable, but the English law has not so far developed to the stage of treating it as criminal." And the duty to act is a very interesting topic and should be dealt with in an episode by itself. We now come to the menswear in criminal law, and the menswear is often referred to as the guilty mind. Only those responsible for the actions should be held criminally blameworthy. The process of choosing to commit a crime is a mental process which involves cognition, knowing or realizing that a consequence could occur or that a circumstance could exist. The mental state became known as menswear. Accordingly, the term menswear is no more than a tool in the identification of culpability. Menswear is often described as the mental element in a crime. It can include what used to be known as malice aforethought, that is, conscious planning or intent, as well as something culpable but less deliberate, such as recklessness or negligence. A crime which does not require any proof of menswear to secure a conviction is known as one of absolute liability. A crime in which one or more elements, but not all, of the Actus Reus requires no proof of mens rea, or that requires the defense to disprove criminal intent once the prosecution has established a prima facie case, is known as one of strict liability. And for absolute offences and strict liability offences, this will require an episode by itself. A seminal case in the area of menswear is the case of Sweet and Parsley of 1970. In this case, the House of Lords considered the offence of being concerned in the management of any premises used for smoking cannabis, contrary to Section 5 of the Dangerous Drugs Act of 1965. The defendant in this case was convicted despite being aware that her premises were used in that manner. Her appeal to the House of Lords was allowed. The court held inter alia that mens rea is an essential ingredient of every offence unless some reason can be found for holding that it is not necessary. And the court ought not to hold that an offence is an absolute offence unless it appears that that must have been the intention of Parliament. In his judgment, Lord Diplock cited with approval the analysis of Stephen J. in an earlier case, the case of Regina and Tolson of 1889, when he said that the full definition of every crime contains expressly or by implication a proposition as to a state of mind. Therefore, if the mental element of any conduct alleged to be a crime is proved to have been absent in any given case, the crime so defined is not committed. Or again, if a crime is fully defined, nothing amounts to that crime which does not satisfy that definition. Lord Diplock went on to explain that the case of Tolson laid down as a general principle of construction of any enactment which creates a criminal offence that even where the words used to describe the prohibited conduct would not in any other context connote the necessity for any particular mental element, they are nevertheless to be read as subjected to the implication that a necessary element in the offence is the absence of belief. Held honestly and upon reasonable grounds in the existence of facts which, if true, would make the act innocent. There are different concepts of menswear, for example, recklessness, intention, and negligence. Most require proof of a person's state of mind at the time of the offence or at the time when the offence was committed. Did the defendant intended or foresee the consequences or risks of it occurring? This is referred to as a subjective test. Abner Justice, or Abner J., summing up to the jury in the case of Hyam and Director of Public Prosecution in 1975 said the following, and I quote, "There is no scientific measurement or yardstick for gauging a person's intention." And in the later case of Regina and Moan, of 1976, intention was defined as the decision to bring about the prohibited consequence. In the case of Nedrick of 1986, Lord Lane, Chief Justice, said the following: the jury should be directed that they are not entitled to infer the necessary intention unless they feel sure that death or serious bodily harm was a virtual certainty, barring some unforeseen intervention as a result of the defendant's actions, and that the defendant appreciated that such was the case. So here we see where the courts have had a very hard time in actually pinning down and narrowing down intention. And the court appears to believe that it is necessary to give very clear and forceful directions to the jury concerning intention, concerning state of mind, because it is something that only could be inferred from the facts of the case, from the circumstances surrounding the offense, because the court have said earlier, in earlier cases, that there is no measurement, there is no meter, there is no gauge, and that intention has no precise mathematical calculation. In the Turks and Caicos Islands, for the offense of murder, the menswear is the intention to kill, and nothing else will do. Under the offences against the persons ordinance, Section 3 states, subject to the provision of Section 4 of this ordinance, whoever intentionally causes the death of another person by an unlawful act or omission is guilty of murder. So in the Turks and Caicos, the Actus Reus is an unlawful act or an omission in relation to murder, and the menswear is an intention to kill, an intention to cause death. Therefore, the law of the Turks and Caicos Islands, where murder is concerned, does not lend itself to the proposition of foreseeing serious bodily harm as a prerequisite for the offense of murder. And in my respectful submission, any direction by the trial judge to the jury to this effect will, in my view, constitute a misdirection likely to result in any conviction being overturned. So in conclusion, in criminal law, the Actus Reus and the menswear are like Siamese or conjoined twins. Without the guilty act and the guilty mind coinciding, there is no offense committed except in the rarest of circumstances. And that would be in the cases of strict liability offences and absolute offences, etc. As a matter of disclosure, in preparation for this presentation, some of the work that was produced came from the textbook Clarkson and Keating criminal law. I thank you for listening, and I will see you in a subsequent episode.